My name is Katrin Hodder and I'm one of the Senior Registered Migration Agents here at Migration Down Under. Are you an employer with sponsored and non-sponsored foreign workers working within your business? And are you prepared for a Department of Home Affairs immigration audit or compliance activity? Today we're going to be talking through some of the key requirements as a business sponsor and what some of your obligations and requirements are. The spotlight on Australia's migration program continues to intensify. We're seeing stricter enforcement of labour laws and greater scrutiny of employment practices. The government is also focused on ensuring our most vulnerable workers are protected and that we've got fair treatment for all. With the Migration Amendment Strengthening Employer Compliance Act enacted in February of last year, we've had further enhancements to employer sponsorship compliance requirements and protecting migrant workers from exploitation. There are several legal obligations and responsibilities for employers under immigration law. There are three key compliance areas that we'll focus on today. One is sponsorship obligations. Two is visa conditions and making sure your employees have appropriate work rights that are within your organisation. And three, ensuring you have appropriate record keeping in place, should that be required to be presented to the Department of Home Affairs or Australian Border Force or other agencies as part of your sponsorship obligations. The sponsorship obligations are in place to ensure the working conditions of a sponsored visa holder meet the requirements under the Fair Work Act. It's also to ensure employers are not exploiting their foreign sponsored workers, and also to ensure that the visa programs are being used in the way that they are intended to be used. There are a number of sponsorship obligations, and some of these include making sure that your sponsored worker continues to work in the occupation for which they've been nominated. Can include things such as ensuring return travel costs are paid for the individual if that's been requested in writing at the end of the person's assignment, ensuring equivalent terms and conditions are met for the sponsored worker, providing immigration details of certain events that occur within 28 days. And this can include things such as the appointment of new directors, a change of location, of business address changes, also notifications of an individual's cessation of employment. Number two is ensuring that your sponsored and non-sponsored work holders are complying with the conditions of their visas. As a business, you should be undertaking regular visa entitlement verification online checks on a regular basis to ensure that individuals do have a valid right to work, or there aren't any restrictions in place which might reduce or limit their work activities with your business. For example, student visa holders may only be able to work with you up to 48 hours a fortnight when their course is in session. Number three is all about record keeping and making sure that you have documents on hand and in a reproducible format that could be presented to the Department of Home Affairs should an audit or compliance activity take place. Some of the records that you should ensure that you keep on file include things such as a position description, employment contract, details of how much the individual has been paid or is remunerated. It's also about keeping the visa grant details and passport information on file. There are a number of consequences for failure to meet your sponsorship obligations or employ foreign workers who might be in breach of visa conditions. These may include cancellation of your business sponsorship. You can also be banned or barred from making further sponsorship applications or sponsoring foreign workers. You may also be issued with an infringement notice and could also face civil and criminal penalties or be issued with an enforceable undertaking. There can also be a number of work-related contraventions that apply where you employ, refer, coerce or contract with a foreign worker, whether that's sponsored or non-sponsored, who might be seen to be in breach of their visa conditions. That is, they might be considered an illegal worker. So as you can appreciate, there is a lot of information that employers need to take on board in terms of sponsoring foreign and non-sponsored workers within your organisation. So how can Migration Down Under help? Well, we have extensive experience across the team in helping our employers and corporate clients meet their sponsorship obligations, whether that be providing a consulting or advisory service, how to respond to Immigration Department of Home Affairs audits if they are requested, or even down to notifying of certain events that might be needed to be shared with immigration in compliance with your sponsorship obligations. So feel free to reach out to any of the registered migration agents here at Migration Down Under, and we'd be happy to support you on this journey around employer compliance.